Your return to my CryptoQ Media channel is much appreciated. The SEC is in the midst of a race against time. Will they be appealing? Everyone actually. I plan to spend the whole film talking about just one topic. An attorney who is active in the XRP community recently shared some fascinating information with me, so I thought he might as well share it with you. Is an appeal possible? I share everyone else's curiosity. What does this have to do with anything? I should preface this by saying that this is merely my humble opinion. The more I've thought about it, the more I see that I never formally predicted anything regarding the subject. If forced to make a prediction, I would have to twist someone's arm to get out of it. So, got it, a swift choice must be made. It would be the easy thing to say no, but I'm afraid it would come out badly. If the SEC were to give that more importance, it would be because it actually benefits them. The S in SECV, though, repeats itself too much. It is amazing how often the SEC acts in a way that is not beneficial to themselves. What makes the SEC members responsible for this is their filthy behavior, inflated sense of self-importance, and egotism. The reason they haven't made a daring prediction is precisely why I'm giving them props. Time is of the importance, yet anything may happen. I wouldn't be surprised if it happened. After that, think about, what would the repercussions be? I have a feeling that the majority of XRP holders are already aware that the cryptocurrency has legal certainty, regardless of what happens. I don't think this will have much of an effect, but it's possible that the market could get scared and XRP's price could drop a little. I don't, mostly because of the label. Even though it may appeal, the SEC will not be contesting XRP's legal status. The fact is that they have previously stated their intention to not do that. I think it's due in part to the fact that, as Hogan noted over a year ago, they aren't able to appeal Judge Torres's remarks about XRP since they were dicta, a crypto fundamental headline. If the SEC wants to challenge Ripple's ruling, they can do so now. With just 39 days to go until the appeals deadline, the SEC must reply to the court's ruling in its continuing legal dispute with Ripple. Just so you know, this was as of yesterday, but wait, there's more. While Ripple and the XRP community revel in their hard-won partial triumph over the SEC, they should not lose sight of the crucial date that will conclude the protracted legal struggle. It is not yet apparent whether the top regulator will challenge the partial success on August 7th. However, it has until October 6th to do so, and the Ripple legal team also has that much time to challenge particular parts of the rulings that the SEC won. SEC v. Ripple ended in a mixed bag of a verdict for the court. Stuart Alderati, Rebels, the chief legal officer, and Brad Garland House are among the Ripple executives who have openly stated their belief that this is a triumph. They have already shown their willingness to pay the fine that was imposed. A fine of $120 million or $5 million is levied against them. Maybe they have the money in their bank account already, so it's not a problem. I think they just want this to end so they can move on, since it won't affect their business strategy. Sure, it's not. That is to say, they are excellent. In my humble view, Ripples do not possess any attractive qualities. Perhaps I am mistaken. Basically, I'm quitting on the SEC. If I were to guess, I'd say they won't, but for the reasons I gave at the beginning of the film, I'm not really certain of that. No matter what happens, the peace will remain because a judge previously ordered XRP to pay a $125 million fine to the US. She said that the regulator had 60 days to appeal before the remedial decision was finalized. The top US regulator's original punishment proposal for the digital payment behemoth was $2 billion, but it was lowered by an incredible 94%. To put it simply, it was obscene. That just could not have transpired. This is something I have to emphasize in another work, which I will not read. Here I might locate a quote that he said. The Crypto Basic Bag from August 16 does, however, contain this. That was the moniker given to the planned SEC appeal wave. CLO estimates that the number of appeals that lead to a reversal is less than 10%. As a result, depending simply on appeals to play, the odds will only lead to a 10% victory rate. Plus, with that much effort, there is a great deal of risk. Regardless, Stuart, I think you understand. Assume I'm right. Besides that, he did say that he wouldn't be surprised if the SEC still appeals. It is not their ignorance, he said, but their haughtiness and abject filth that set them apart. Their inability to calculate is unrelated to their poor decision-making. They require a great deal of mental energy. Because of their terrible nature, they are always making bad decisions that hurt themselves. Bill Morgan, an attorney and member of the XRP community, provides his perspective on the subject. If the choice to appeal is only grounded in legal grounds, as he indicated 2 days ago, I am growing less and less certain that the SEC would appeal the Ripple summary judgment decision. As I said in yesterday's post, Judge Orrick sided with Judges Jackson and Torres in the Binance and Ripple cases, which distinguish between transactions on the primary and secondary markets, rather than Judge Rackhoff in the Terraform case, who did not. This decision occurred in the cracking case. In the Terraform case, critics made a great issue about how Judge Torres' reasoning was inconsistent with and, in their perspective, reflected negatively on Judge Torres' thinking regarding programmatic sales. Those who were familiar with the Follies cases may remember this. Judgment in the Ripple summary judgment decision was largely positive on Judge Torres' reasoning. However, Judges Orrick and Jackson in the Kraken and Binance cases had a different view. Can assuage the fears of naysayers like Charles Gasparin, who cast doubt on her judgment. Charles Gasparino is clearly famous among XRP users. As host of Fox Business on the Fox Business Network, he thinks the Torres decision was entirely pointless. To his dismay, he mistakenly thought that XRP could only represent a choice or security in certain contexts. Having read his whole piece, I must respectfully disagree with him. The significance of this information for my memory is clear, even though I can't recall all the specifics. See, the other judges disagree with what Torres said, he would later assert anytime his perspective was questioned. For a long period, this trend persisted. There seems to have been no time at all, yet here we are with a pair. For other crypto cases, all that's required is time. Nevertheless, her case has backing from attorney Bill Morgan, who cites her in other cases. The fact that this is Charles Gasparino's perspective suggests that it will age gracefully, which it has done thus far and will continue to do in the future, no doubt. He informed Charles Gasparino, "Hey, you know this isn't necessarily gonna go well for XRP and holders due to his involvement in another matter. As far as you're aware, things are subject to change. The SEC has already said they won't appeal the decision on whether XRP is a security, and I'll go even farther and say that's because, honestly, they can't. The ordinary XRP holder is more concerned with XRP's standing and its ability to be traded on open markets than they are with knowing the SEC wins the institutional side. This is something I've discussed before. That, too, was understood. In that case, it's a massive one. As long as it has something to do with the case, I'm interested in hearing more, but other than that, it doesn't interest me. As a result, my life will remain unchanged. Your attention in seeing my web video is greatly appreciated. For the time being, I ask that you like and subscribe to my channel.